I'm Sid Mendelson. On my left is Tim Cox. On my right, Laura Bond, and on my far right, Jerry DeMichaelis. Okay, Tim.
Thank you, Sid. First, I'd like to discuss with you briefly Section 27, which is the sales load provision of the statute as it applies to periodic payment plans, and then get into a further brief discussion on what a variable annuity is, which is issued by an insurance company, and Laura will discuss the rules. The reason that that particular topic has been chosen here is that a variable annuity contract is viewed as a periodic payment plan subject to Section 27. And I might also add that separate accounts, most separate accounts that issue a variable annuity contract are unit investment trust. A periodic payment plan certificate means any certificate, investment contract, or other security providing for a series of periodic payments by the holder and representing an undivided interest in certain specified securities or in a unit or fund of securities. The periodic payment plan certificate contemplates an advantage to the investor should the investor complete the plan, and a disadvantage if the plan is not completed. Section 27 makes it unlawful to sell any periodic payment plan certificate if the sales load exceeds 9%, and that's over the life of the plan. The section permits various modifications of the sales load. I might also mention that it is becoming more and more important these days as terms change. The term sales load is defined in Section 2A35, and I won't get into that definition here, but we have given an exemption in at least one case to a company from that definition. And I believe that the variable life rules under 6E also contain another definition of sales load. This Section 27 permits the depositor or the underwriter to deduct up to 1/2 of the purchase payment for the first 12 monthly payments. And that's the Commission has felt that was quite a lot to skim right off the top, and in 1966, in the Public Policy Implications Report, the Commission suggested to Congress they may want to do away entirely with that type of permission. As subsequently adopted in 1970, Section 27 was expanded, and it subjected depositors and underwriters of periodic payment plan certificates to further provisions. The first point that I think is important to focus on is that 27G permits an election by depositor to use 27A. And 27A is the provision where they can impose a 50% sales load on the first 12 payments. Or they can elect what was then new Section 27H with a more spread out sales load. 27H permits a 20% deduction from the first 12 payments. 27H also contains a provision that not more than 9% over the life of the contract can be deducted for sales load. I'm interchanging these sections, and if anybody finds that confusing, please raise a question. Going back to 27A, the amount of the sales load on the first 12 payments must be equal. There could, unless without an exemption, there could be no discount on those first 12 payments from the sales load. And that section also provides that the first payment must be $20, and then any subsequent payment $10
Minimum.
as a minimum. Apparently, at the time the statute was adopted, people were being solicited at very nominal amounts. 27C requires the periodic payment plan certificate to be redeemable. That can be extremely important as you look at some of these certificates to determine whether or not there is a redemption fee. If there is a redemption fee, one has to consider to what extent that might impact on the redeemability of that certificate. Also, 27C provides that the proceeds of the payment, except the sales load, have to be deposited with the trustee of the type defined in Section 26. And that can present problems, and it does present certain problems for insurance companies where administrative fees are taken from the payment in addition to the sales load. And that requires an insurance company to come before us and justify its fees in order to get an exemption. And 27C requires the indenture, if there is one, or the contract, must have the provisions as those described in Section 26. Now 27D, which is, well, 27D, E, F, G, and H were all added by the 1970 amendments. 27D made it unlawful to sell a periodic payment plan certificate under 27, if it was sold under the 27A, unless the holder can surrender it at any time within the first 18 months and receive the value of his account plus an amount equal to the excess for sales loads over 15% of gross purchase payments. This particular provision made 27A very unattractive to the issuers within this community. And some of them subsequently adopted 27H, and for the most part, at least in the variable annuity area, the new periodic payment plan certificates are level load at a sales load less than 9%.
Why it made it unattractive should be obvious. If a person could get back all of his load except 15%, it meant that the broker-dealer hiring salesmen couldn't really pay them with impunity until the time had passed that the investor could turn back the securities. If he paid them and they left his employee, he was out the money himself. So it was obvious that he had to carry a contingent liability for every sale he made, because the customer could always claim back a certain amount of his load.
Thank you, Sid. 27E, also added in 1970, is basically the notice requirements for the depositor underwriter. Anytime within 30 days after the expiration of 15 months from the date the certificate was issued, any certificate holder missing 3 payments or more has to be notified of his refund rights. The notice that must be sent out must identify the right under 27D, indicate the value of the account at the time of the notice, and the amount of refund that he would be entitled to. 27F is the provision which requires that periodic payment plan certificate issuer offer a 45-day free look, but only if the sales load is greater than 9% for any payment. And then it is up to the sponsor to arrange for the custodian to issue within 60 days after the date of the certificate a notice to the holder that he can completely withdraw and receive the value of his account and all other monies that had previously been deducted for sales load, administrative fees, whatever.
Now, what is happening here, I think you can see, is while they didn't outlaw front-end loads, they made it so unattractive for anybody to sell them that they all but eliminated front-end loads. That's the message you can come across, that should come across to you. There are very few, if any, front-end load plans going on today, with all of these rights of the purchaser to return the goods, if you will, and get a portion of his sales load back. It makes it extremely unattractive product to sell.
There are many technical rules under these provisions, and I won't get into those here, but to the extent that these things may revive someday, the rules may become important. 27G is the provision which permits the issuer to make an election to use the 27H, and 27H would now allow the sales load to be stretched out so that over a 48-month period, the average sales load does not exceed 16%, and during that period not to exceed 20%. Then there are a number of criteria under 27H. All of them vary and are different and independent of one another. The sales load on any one payment of the first 12 well, that 27HD provides that the sales load cannot, during the first 12 payments, that's the maximum load that can be applied.
This is the trick. They take 12 months. They take 12-month periods, and they say you can scale down your sales load each 12 months for the 48-month period, and each 12 months the sales load has to be the same, and it cannot be higher than the sales load of the first 12 of the previous 12 months until you get down to 48 months. At which time you get into what is known as trails loads. In other words, at that time you can charge whatever you have to make the charge not exceed totally 9% for the completed package.
That's right. And the last once you've passed the 48 months and then you're in the trail load, or even at any time prior to that, the question might come up: what would happen with respect to an advance payment? And 27H provides that the sales load, basically on an advance payment, which is accepted by the underwriter or depositor, cannot exceed the sales load in effect after the 48th monthly payment. So the sponsor would not view that as a very profitable acceptance.
So that the Congress really did indirectly what the Commission asked them to do directly. And they did it by making it, as I said before, almost a totally unacceptable product to the seller.
If I can, I'll answer any questions anybody may have on Section 27. If there are no questions, I'll try to indicate some practical applications in the variable annuity area of what happens. I've used the term variable annuity, and I'm not sure very many people understand.
I explained a little bit about it yesterday.
Let me go into a basic function of an annuity. A life annuity is basically a contract issued by an insurance company under which it agrees to pay to an annuitant a stipulated sum, otherwise known as an annuity, periodically throughout the annuitant's life, and upon death, the principal sum standing to the credit of the annuitant is liquidated immediately by the insurance company, and the principal amount become the assets of the insurance company.
Which means in its worst sense, if you go on an annuity, you get the first month payment and die, your estate is through. The insurance company has made everything you have put in goes to the benefit of the insurance company. On the other hand, if you live to be 175, the insurance company loses, and that's the chance it takes. The chances of you dying in the first month or living to 175, the chances are it's a little bit more remote that you'll live to be 175.
Well, that's it's one of the options. You can have a life contingency where your highest monthly benefit will be to have that type of option, where if you died after 1 month, that would be the end of it. There are other types of options under these contracts, and to the extent there is more risk to the insurance company, the less attractive the options are. But I did want to mention that the principal purpose of an annuity is to protect against a risk, and as Sid suggested, outliving one's income. At 175, probably wouldn't be earning too much income, and which is just the opposite of life insurance, which is usually thought to be bought as a protection against loss of income through premature death. Now, the variable annuity is, I guess I used to say it was new, but I guess it's no longer new. First introduced in this country in about 1952, and in 1959, the Supreme Court held for the Commission in the SEC versus Valak, which can be found at 359 U.S. 65, 1959, that the variable annuity, which transferred the investment risk from the insurance company to the annuitant, was a security not exempted under the 33 Act. It also found that the insurance company was setting up a separate account, and that the separate account had a identifiable pool of securities. The annuitant had a proportionate interest in that pool, and that the separate account therefore could be deemed to be the type of investment company defined in Section 3A of the Investment Company Act, and require the separate account to register.
That's really the Prudential case.
Yeah.
Oh, okay. I'm sorry, I should do that.
You did go into that.
The Investment Company Act of 1940 and a variable annuity contract are not quite as compatible as a mutual fund in the Investment Company Act, and thus, acting pursuant to 6C, we have administrative authority to grant relief, such as that discussed earlier on the custodianship arrangements. Laura will discuss some of the other types of exemptions or the rules that these companies have available to them. I would like to point out that the insurance industry is marketing oriented. It is highly susceptible to competitive pressures, and they're constantly revising their products, including the variable annuity contracts. And while all the states have insurance laws, from a federal regulatory point of view, we cannot ignore the congressional mandate of the Investment Company Act or the disclosure objectives of the 33 Act. But at the same time, we want to recognize our mutual interest with the state authorities and reach some accommodation in our regulatory philosophies.
Generally speaking, in the insurance area, the states are interested in one main thing: that the contract will be complied with by the insurance company. That is, if the insurance company says that it will pay you, that it will pay the annuitant $100 a month for a certain amount of money, that at the time that the annuitant is ready to receive it, there'll be money there to pay him. On the other hand, the Investment Company Act is worried about the excessive charges, is worried about whether people know exactly what they're getting into, and and is interested in how the fund that is going to create the annuity is managed. That is the essential difference between the two organizations, the two regulatory bodies, the state insurance commissioners and the SEC. We are very much interested in regulating how the money is managed and whether or not there is any overreaching. Now, the insurance company, the insurance commissioners don't ignore that, but they don't emphasize regulating the charges, except as I understand it, on one type of insurance, and that is casualty, where they regulate the charges, but not, generally speaking, not in annuities and not in life insurance.
That's right. In casualty insurance, they actually will set the rates, as everybody knows who buys car insurance.
That's right. Now, maybe one ought to understand how a variable annuity works. I'll give a very short explanation. There are two periods of time. I'm speaking generally. There are variations, myriad of variations, but there are two periods of time in which at which point a variable annuity works. The accumulation period and the annuity period. The pay-in period and the payout period. When an insurance company, when a person is paying into the insurance company, the annuity units, just like shares of stock, are given a value. They start off, generally speaking, at $10 a share. These will fluctuate in the same way that stock will, almost the same way that stock. If the investment company, if the annuity pool, the separate account, goes up by 10%, those units, not those accumulation units, will go up by 10%. If it goes down, those units will go down 10%. And with each payment, you buy more annuity units. Accumulation units. Now, at the time that you go to annuitize, you can either take your money out and leave, or you can go into a variable annuity at that point. It's almost as though you have the option of saying, give me my money, and now I'm going to tell you what to do with it. Well, if, for example, they figure out the value of all your accumulation units, and let's assume you had $35,000 worth of accumulation units. And then they say, well, according to the contract we gave you, we're going to pay you, for the initial payment, $6 per thousand. So they would divide. They would divide the number of accumulation units by 1,000, say, for example, and they say you have 35 units. 35 units of annuity units. You had 35,000, so now you have 35 units, which pay you for the first payment $6 each. So you people with calculators can figure out how much 6 times 35 is. Now, the next month, if the fund goes up 5%, you get $6 plus 5% of $6. If it goes down, you get $6 per unit minus the percentage that it went down, and the value, the number of units that you have will remain forever. The value of how much, now the only thing that's left is how much you get paid on those units each month, and it goes up and down as the fund goes up and down. So that 15 days, and this changes with each insurance company, but the ones I'm familiar with say 15 days before you're to get paid, they figure out the value of the unit, the value of the what they call annuity unit, and they pay. They may some months they may pay $6.35. Another, and if the market continues to go up, they could conceivably pay $7 a unit. If you have 35 units, you multiply that by 35. If we were in the doldrums, as we were several up until very recently, you would probably get less. You might get $5.50 or $5.25. But generally speaking, you'll continue to get an annuity based upon the record of the investment company. Now, the insurance feature of it is that you can live forever, and that insurance company says, even though we'll pay you much more than $35,000, which you put in the annuity at the time you annuitized, but we'll guarantee that we'll pay you as long as you live if you have a full life. Now, a good number of people have what is known as a guaranteed 10 years. In other words, they'll get less. Instead of $6, they'll get $5.75, but they are guaranteed that for 10 years they'll receive payments, and when they stop, if they die, their estate will get payments for the remaining period remaining in the 10 years. Or you can have, for example, you can have what is known as a life and a half. Your life and the life of your spouse or any other person you nominate. This is still a lesser. You get less for that. Maybe you get. I'm just making this up. $5.25,000 instead of $6. But you're working it over 2 life periods rather than 1 life period. That gives you a very capsulated idea of how a variable annuity works. Now you can see that the risk of investment is on the investor, whether he gets more or less. There is an insurance feature that you'll get paid for the period they say you'll get paid for. But how much you'll get paid depends upon the record of the portfolio, and therefore the investor assumes the risk. And that's the difference, as I said yesterday, between insurance, pure insurance, and securities. Any questions? Go ahead.
You do?
I think it's probably appropriate to
separate accounts, as Tim mentioned, don't fit very well into the framework of the Investment Company Act, and so over the years a number of rules and parts of rules have been adopted to deal with this fact. 5 of these apply only to accounts which fund tax-benefited variable annuity contracts, primarily 403 plans qualified under 403B of the Internal Revenue Code. I'm not going to go into these in detail. They are, people have mentioned and will mention them. One of them, for example, Rule 14A2 exempts such accounts from the minimum capital requirements of Section 14.
You can see why. I mean, you don't need earnest money for an insurance company worth $8 billion. I mean, they have the money to carry on. It's just a matter of sense, common sense. You don't need that protection.
Another exemptive rule for variable annuities is Rule 22D3. This allows variations in the sales loads and the charges which are reflective of differences in costs or services and are not unfairly discriminatory and are disclosed in the prospectus. This is intended primarily for contracts which are sold to large groups, where companies often offer reduced sales loads or reduced per unit administrative charges because there are economies of scale. And Rule 22D3 permits them to do that if they disclose what they're doing. Rule 22E1 says that it's okay to suspend the right of redemption during the annuity payout period, where payments are based on life contingencies. Well, you have to. You can't have a redeemable security and also have an annuity.
But obviously, a person who has a life annuity and goes to the doctor and discovers he has terminal cancer would immediately want to redeem. At which point, everybody doing that, one could not insure against that. So it's obvious that once you start your annuity period, you cannot redeem any further. And otherwise, you couldn't have an insurance feature.
Right. It would be inconsistent with the whole idea of an annuity contract. Then there are 5 different rules under Section 27 dealing with the levels of sales loads that are permitted to be charged in the sale of variable annuity contracts. For example, Rule 27A1 provides that the maximum 9% sales load is to be computed over a 12-year period in a variable annuity contract. This is because, unlike a contractual plan, a variable annuity contract is of indefinite duration. You can't say, well, you're going to compute the 9% over the 20 years of the plan. There is no 20 years of the plan. It goes on as long as the person lives, or continues in the accumulation period, which is indefinite. So this provides an arbitrary period for computing that. Another fairly important rule applying to variable annuities is Rule 27A2, which permits any sales load structure that's either level or declining. That is, the sales load on any payment must be either equal to or less than the load on the prior payment. It can never be greater. This is a rule under which there are frequent applications for exemption because insurance companies, for example, will charge no load at all on proceeds from other insurance contracts that are then turned over and invested in the variable annuity. And then if a person later invests more money, they'll go back to charging a sales load.
Yes, well, the whole idea was, the idea behind the rule was not to suck a person in, frankly, by charging a very small load at the beginning and then increasing the load after he was already in. But the logic of giving the exemption was that you let the person take, say he wanted, for example, he wanted to liquidate a life insurance policy. He no longer had need for the life insurance policy, so he takes his cash surrender value out of the life insurance, and rather than charge him an ordinary load to put that in, they, as an incentive, they say, we'll put that in the variable annuity and we won't charge you anything, or we'll charge you 0.5% or whatever they want to charge. But understand at the time that if you put any more money in, we're going to charge you the regular load. But because we had already sold you this other policy, we will not charge you another sales commission for using that to get into a variable annuity. It makes perfectly good sense in that if we didn't give the exemption, they charge them a regular sales load to get them in. So this is kind of protection we don't need to give people.
Right. And I'd just like to mention briefly some of the common exemptive orders that separate accounts have. Many separate accounts are organized as unit investment trusts, as was mentioned, in a series form with a number of mutual funds as underlying investment media, and they permit exchanges so that a person whose investment objective changes or who simply changes his mind can shift his investment from one fund into another. And we take the position that that requires an exemptive order under Section 11, where it's a unit investment trust, and many funds have such orders, and many separate accounts have such orders. Also, many separate accounts have orders under sections 26A and 27C2, when they're organized in the form of a unit investment trust which sells periodic payment plan certificates, section 27C2 requires that everything except the sales load must be put into qualified bank, which is acting as the trustee or custodian, and the exemption then would allow the insurance company to organize a separate account without having such an arrangement, to use the open account system for underlying fund shares, to have custody of the assets of the separate account, and to, as Tim mentioned, take out not only sales load but administrative charges, which the order would commonly say that the Commission retained jurisdiction over whether such charges were reasonable or not.
What I think Laura is trying to illustrate is that we have used Section 6C to tailor the Act to fit the product that is being sold. That 6C gives the Act such elasticity that the Commission, upon the presentation of evidence, can form, if you will, the regulatory pattern to fit the needs of the investor for that particular product. That's a very ingenious thing when you think about it. Other acts, such as the 33 Act, doesn't have that. Do not have that elasticity, and the staff at times has a very difficult time administering that statute. But fortunately, the 40 Act does have that rubber in it, and which makes it a workable act. Otherwise, these companies, this type of investment company, could not exist without relief. They just couldn't do it, and because it isn't. The act was never made for this peculiar product, and so we changed in effect, the Commission changes the act to fit the need.
I might just mention that another peculiar product that doesn't fit the Act is variable life insurance, and for that there is one rule, Rule 6E2, which tailors the Act to variable life insurance separate accounts. And one of the things that the Investment Company Act study will be looking at is the possibility of taking all these rules and pieces of rules that apply to variable annuity separate accounts and consolidating them.
Well, for those of you who know what variable life insurance is, I'll take 2 minutes and tell you that variable life insurance is really, to be very simple about it, it starts off with a minimum protection, say $10,000. That's the least amount you can get. I mean, if that's what your contract calls for. If you want to take $30,000, that would be the least amount. Your estate would never get less than the minimum. As a practical matter, the premiums are set, and the dividends which you might receive, instead of receiving them, are used to be put in a pool of securities, which could go up or down. If those securities go up, up over a period of time, then the amount of protection that you get for the premium will go up. And conceivably, there were times when that $10,000 might double. Now, unfortunately, the concept of the variable insurance came out just about the time that the stock market was going down, and therefore it was viewed by most insurance companies as a totally unsaleable product. And today, as far as I know, only one insurance company, the Equitable, is offering this policy. Under those circumstances, the theories behind it are something we would discuss in the future, because we are having only one company. I'm certain that very few of us will be concerned with it.
Right, there are not many people to inspect. I'm going to turn it over to Jerry now, I think.
Thank you, Laura. I'm going to talk for a moment on sections 18I and section 16 of the 40 Act. Section 18I. Section 2A42 defines a voting security. Section 18I reflects an early awareness of shareholder democracy in saying that every share of common stock issued by a registered investment company shall be a voting stock and have equal voting rights with respect to every other share of outstanding voting stock. The exceptions are closed-end investment companies, which may issue a senior security that is a stock, and common law trusts described in section 16C. There's also a grandfather clause for firm contracts, warrants, and subscription rights, which were outstanding or entered into prior to March 15th, 1940. 18I is a fairly straightforward section in its meaning, in that each share has an equal and proportionate say in the control of the investment company in electing fund directors, an equal and proportionate claim on earnings of the company at dividend and capital gains distribution time, an equal and proportionate share in the approval of investment advisory contracts required by Section 15, and an equal say in approving who will oversee the audit of the books and records of the company. It does have an interesting application in connection with limited partnerships as investment companies. In the past, it was not feasible to organize a fund as a limited partnership because state law did not authorize voting powers for the holders of limited partnership interests. That meant that a registered management company organized as a limited partnership could not fit the requirement of Section 18I, which required that all issued shares be voting shares and have equal voting rights with all other outstanding shares. Moreover, in light of this, such a company would not be able to comply with Sections 13, 15, 16, and 32, all of which require votes of shareholders.
Now, this was the fault of state law because, as you remember from those of you who are lawyers, in partnership law, when a limited partner has a voice in the management, he's no longer a limited partner. And therefore, giving him a vote in strict states would to a large extent, put his limited liability in jeopardy. And he would become, conceivably, a general partner with unlimited liability. So that was the problem. The problem wasn't with the Act. The problem was with the states.
The California Corporation Code was amended to authorize certain voting powers to limited partners without the exercise of such powers considered to be part of the control of the business for the purposes of maintaining the limited liability. This change in the California Code made it possible for such partnerships to meet the 18I voting requirement. Section 16, changes in the board of directors of an investment company. Whereas Section 10 talks about the qualifications and limitations as to who shall serve as a director, Section 16 talks about the mechanics of election to the board. The board of directors shall be elected at annual meetings or special meetings called for that purpose. Section 16A prohibits anyone from serving as a director of a registered investment company unless elected by the outstanding voting securities, here again a tie-in to 18I, except that vacancies may be filled in any legal manner that's in accordance with the state law of incorporation, as long as 2/3 of the board are those who have been elected by shareholders. In other words, if you have a 3-man board and each was elected by shareholders and one dies or resigns, one can be appointed by the remaining directors. If at any time less than half of the board is comprised of directors elected by the outstanding voting securities, here again a tie-in with 18I, the company must call a meeting of shareholders within 60 days, although the commission may extend that time by order. The directors may be divided into classes, provided that no class is elected for less than a year or longer than 5 years, and that the term of office of at least one class has to expire each year. Section 16B talks about vacancies as a result of attempts to comply with the provisions of another section of the 40 Act, Section 15F1A, which says, where there is a sale of an investment advisor for a period of 3 years thereafter, at least 75% of the members of the board of directors may not be interested persons of either the new advisor or the outgoing advisor. By way of a footnote, Section 15F1A overturned Rosenfeld v. Black, which held that the sale of an investment advisor for a profit was a violation of the advisor's fiduciary duty to an investment company. In connection with such vacancies, they must be filled by a person who has been selected and proposed for election by a majority of the directors who are not interested persons of either the new or the outgoing advisor, and a person who has been selected by the shareholders of the fund. There is an exception, however, where a director resigns or dies. The vacancy can be filled in accordance with the terms of 16A, which I mentioned earlier. Section 16C.
Let me comment on 15F. The purpose of having 75% disinterested directors and the way they were to be nominated and the positions filled was because they didn't want the new investment advisor to put in his friends, who would then make sure that the contract he paid for, he could perpetuate. So this new independent board, the theory goes, would be looking at him with a dispassionate view. And if they didn't like him, they could get rid of him. That was the theory.
Thanks, Ed. Section 16C involves the removing of a trustee. Section 16C applies to a very specialized situation. Firstly, it accepts pre-40 Act common law trusts from the requirements of Section 16A and B, where the trust indenture fails to provide for the election of trustees by the shareholders. The section further states that no natural person may serve as a trustee to a trust that is a registered investment company if 2/3 of the outstanding shares of beneficial interest declare that a trustee should be removed from office either by a declaration in writing filed with the custodian or by votes cast at a meeting called for this purpose. The trustees are required to promptly call a meeting of shareholders for the purpose of voting on the removal of a trustee if 10% of the outstanding shares have made the request, 10 or more shareholders who have been so for at least 6 months and who hold at least 1% of the outstanding shares, or shares with a net asset value of at least $25,000, whichever is less, can apply to the trustees in writing, stating that they want to communicate with other shareholders in order to get signatures, asking for a shareholder meeting. Within 5 days after receiving the shareholder application, the trustees have to either give the names and addresses of the shareholders or inform the shareholder petitioners as to the number of shareholders and the approximate cost of the mailing of these communications to the shareholders. If the trustees opt for the latter choice, then the 1% group has to supply the mailing and the funds for paying for it, unless the trustees inform the Commission that the proposed mailing contains untrue statements and are misleading with reasons for the trustees' opinion. After an opportunity for a hearing, the Commission may enter an order sustaining or refusing to sustain the trustees' objection.
I've been here for a long time, and I have never seen this procedure used at all. The idea of trusts is somewhat passé in the investment this type of trust in the investment company business. So its worth is more historical than it is present day.
A couple of interpretive requests under Section 16. What happens when a new board position is created? Can the person elected to such a position be elected by the other directors? The answer is yes. The filling of such a seat is the filling of a vacancy contemplated by 16A. Again, general partners to a limited partnership are analogous to directors of a corporation. What happens when one or more of the general partners is a non-natural person? The first interpretation the division sent to Kader Brothers in November of 1974 questioned whether the inclusion of a non-natural person, such as a corporation, for example, as a general partner, i.e., a member of the board of directors, would be consonant with the provisions of the Act. Subsequently, when the Section 18I problem of the inability of limited partnership interests to have voting rights was resolved through a change in the California Code, a few companies began registering for the first time as investment companies in the form of limited partnerships. Following this, the division in the Van Sanders Exchange Fund memo to the Commission raised no objection to a corporate entity, in this case Van Sanders, which acted as investment advisor to the fund, serving as a non-managing general partner of the fund, which was a limited partnership.
We didn't mind it acting as the general partner because it had the deep pocket, and any liability that was going to be assessed in this case would be assessed against Van Sanders, but it would not vote as the as a regular general partner that we set up in lieu of a board of directors.
This meant that Van Sanders couldn't have any part in the management of the fund's business and have no authority to bind the partnership. Obviously, in this case, there'd have to be a natural person serving as general partner who would fill such a role. And in the Van Sanders case, there were 4 individuals serving as general partners. The division was satisfied that Van Sanders, although a general partner of the fund, would not be performing functions on behalf of the fund similar to those of a director of an incorporated investment company would perform. Investment Company Act Release 9889 said that although the guidelines to Form S4 and S5, which are the registration statements under the 33 Act, requested an undertaking that a meeting be held within 180 days after the effectiveness for the purpose of electing directors, the Commission withdrew this requirement because the cost of compliance was greater than the public interest being served. Nevertheless, guidance was given that such a meeting should be held 12 months after effectiveness of the 33 Act registration statement. The rationale of the undertaking was apparently that while a shareholder vote approving the directors prior to the commencement of a public offering was legal, it was in reality a pro forma act, whereas the public shareholders should have an opportunity to vote on them as soon as possible to make the approval meaningful.
The reason the Commission removed this provision, previously the people who owned the shares representing the $100,000 of net worth, the insiders, would vote in the board. The Commission and the staff felt, however, that when the prospectus named the board and asked people to put in their money with this board in place, that the people were really voting with their dollars rather than anything else, and it was a very effective vote. Because if they didn't like the board, they didn't have to buy the shares. So we felt that to cause this investment company to crank up the machinery, the proxy machinery, after 3 months of its existence, was not necessarily for the benefit of shareholders.
Tim?
You got 2 minutes.
Okay, I will just briefly get into Section 16. Actually, not Section 16. Section 30F, which applies to closed-end companies only, adopts the duties and liabilities imposed by Section 16 under the Securities Exchange Act of 1934 upon beneficial owners and certain other persons. That means, essentially, is under the reporting provisions in 16A, a Form 3 is filed by an initial beneficial owner of a closed-end investment company who acquires 5% or more of the outstanding stock. And a Form 4 is filed with the Commission and any changes in that beneficial ownership. I want to mention 16B of the 34 Act, which is the short trading by insiders. If an insider makes a profit on a security of the corporation, which is subject to reporting requirements of the 34 Act, and turns that profit around in 6 months, the issuer or the company has the right to the profit plus interest. And I think that's about all I want to mention about 30F.
In other words, 30F merely adopts for closed-end investment companies the rules under Section 16 of the 34 Act. Thank you.